In this video, we'll be talking about how to manage miscarriages in the workplace. It would be impossible to delve into the physical and, more importantly, the emotional complexities of pregnancy loss in this guidance, but I'll endeavour to address the fact that it is a deeply vulnerable time for all involved. I hope that this guidance provides a deeper understanding for those experiencing miscarriage, as well as those managers or employers who need to manage the employee or partner affected by the loss of a baby in pregnancy. It is estimated that approximately 1 in 4 pregnancies ends in miscarriage, with around 80% occurring in the first 12 weeks of pregnancy. Miscarriages that occur between the 12th and 24th weeks of pregnancy are less common, but still significant. Pregnancy loss after 24 weeks is considered as stillbirth, which is covered by employment law in the UK. The types of pregnancy loss considered within this video are miscarriage, which is defined as a loss of pregnancy before 24 weeks. Ectopic pregnancy, which is where a fertilized egg implants and grows outside the uterus, meaning that the pregnancy is not viable. And lastly, molar pregnancy, and that is where a non-viable fertilized egg implants in the uterus and the baby and placenta do not develop as they should. Now, unfortunately, currently, at least as of the 4th of March 2025 in the UK, there is no specific legal right for an employee to take time off due to loss of pregnancy before the 24th week of pregnancy. But there are several related rights. Firstly, sick leave. Although miscarriages are not considered a sickness, they can result in physical and emotional recovery time, and the employee may be entitled to take sick leave. Employees should be allowed to take sick leave and, if applicable, be paid according to the organisation's sick pay policies or statutory sick pay. Any leave the employee takes after a miscarriage, ectopic or molar pregnancy, should be recorded as pregnancy-related leave. The employee should be able to self-certify that leave is pregnancy-related for the first 7 days. After this, the employee will need a fit note or a sick note or doctor's note from a doctor to say it is a pregnancy-related time off or absence. If the employee returns to work and then realises they need more time off, they'll need another fit note. The employer must record this leave separately and must not use it against the employee, for example, disciplinary or redundancy proceedings. The employee is entitled to any sick pay that they would normally qualify for when off sick too, and the employee can take off as long as they need, as long as they have a note from the doctor. But this is not always an affordable option for the employee or the employer. Concerning statutory maternity or paternity leave, if the miscarriage occurs after the 24th week of pregnancy, the employee would be entitled to statutory maternity leave, assuming they've been employed for at least 26 weeks. And it's important to note that those rights do not apply to those suffering a miscarriage prior to the 24th week. If the baby is stillborn after 24 weeks of the pregnancy, the birth mother can get up to 52 weeks of statutory maternity leave or pay. The birth father can get up to 2 weeks of paternity leave or pay. The partner of the birth mother or adopter can get up to 2 weeks of paternity leave or pay. They'll both be entitled to 2 weeks of parental bereavement leave after they finish off their maternity or paternity leave. So while the legal name for the time off is statutory maternity or statutory paternity leave, some employees may not want to call that time off that, particularly if their baby has died. With regard to pregnancy discrimination, if an employee suffers a miscarriage and feels discriminated against or treated unfairly because of it, they may have a case under the Equality Act. It is unlawful to discriminate against someone due to pregnancy-related reasons. Now, this covers a period of 2 weeks from the end of the pregnancy for women who are not entitled to maternity leave. During this period, the employee is protected from being discriminated against for any sick leave they take because of a miscarriage. After the 2-week protected period, the employee may have a claim for unfair dismissal if they have at least 2 years service, or automatic unfair dismissal if they've been dismissed or made redundant because of something to do with their pregnancy. The employee may have claims for detrimental treatment, direct or indirect sex discrimination, and that is rather than pregnancy discrimination. If they've been disciplined or treated unfairly because of their pregnancy, miscarriage, or related to sick leave. And this protection is not limited to a specific period and applies to a treatment related to the pregnancy or miscarriage-related sickness as well. Some guidance for employers supporting the employee. There are several ways employers can support the employee. Number one, communication. Approach the situation with care and respect. It's important that the employee feels supported and that their privacy is respected. A private conversation should be offered, allowing them to decide how much information they wish to share. Secondly, flexibility. If possible, be flexible with work arrangements. Some employees need more time off than others to deal with the physical recovery, while others might need some more time off for emotional support or therapy. Thirdly, sensitivity. Recognize that miscarriages are a deeply emotional experience. Be empathetic, offer time off for recovery, and ensure that the workplace is not adding to their emotional burden. Fourth, support resources. Employers may want to suggest counselling or support groups. Many organisations already offer employee assistance programs that can also assist. The Miscarriage Association also provides a wealth of information which helps employers and employees alike. Next, offer practical support. Ensure that your sick leave policies are clear and that employers know how to apply for leave. It's important that employees do not feel penalised for taking time off due to having to recover from a miscarriage. Next, confidentiality. It's important to maintain confidentiality and ensure the privacy needed that the employee demands. Next, review workplace policies. Employers should have clear policies in place regarding sick leave, compassionate leave, and any support options for staff dealing with pregnancy-related loss. So consider reviewing your organisation's maternity and sick leave policies to ensure they are clear and compassionate. Although you're not required to do so, you may want to consider implementing a specific miscarriage policy, which does offer time off after pregnancy loss and, if possible, on full pay. Next, training for managers. Ensure the managers in HR are trained to respond sensitively to personal matters like this. Next, we're going to look at some common issues with mishandling miscarriages in the workplace. The lack of rights and clear guidelines in UK employment law for those experiencing a pregnancy loss and their partners causes many issues for both the employer and the employee in the workplace. These include, but aren't limited to, firstly, inadequate time off. Without specific rights for employees, some employers may not fully understand the emotional and physical recovery time needed after a miscarriage. Employees might feel pressured to return to work prematurely, which could result in them feeling overwhelmed, underperforming, or even facing additional health issues. Secondly, impact on employee well-being. If the miscarriage is mishandled, it may lead to emotional distress, anxiety, or depression for the employee. Over time, this can and quite likely will affect their performance and job satisfaction, potentially leading to long-term absenteeism or even a decision to leave and indeed bring a claim against the company. Thirdly, loss of trust in the employer. Mishandling a miscarriage can lead to a breakdown of trust between the employee and the employer. This lack of trust can be difficult to rebuild and may result in the employee feeling disengaged or unmotivated. So some guidance for employers supporting partners. The fact that miscarriages are not recognised in UK employment law at present does put partners and their employers in a more confusing situation as to how time off should be handled. Unfortunately, in the UK, partners are not entitled to paternity-related leave or sickness absence. Time off for partners, whether for their own bereavement or to physically and emotionally provide support for the partner experiencing pregnancy loss, is often at the employer's discretion and can be mishandled. It's important for employers to recognise that using their discretion with compassion and care can benefit employers, employees and their families. There are several ways employers can provide support to their partners. Firstly, allowing time off. Partners should be given time off to support their spouse or partner after pregnancy loss. While there is no specific statutory entitlement for partners, employers should recognise the need for compassionate leave and offer flexibility. Some companies provide paid or unpaid leave for such circumstances, and this can be formalised into company policies. Next, flexible working arrangements. Employers can support partners by offering flexible working hours or the ability to work from home during this difficult time. This allows them to attend medical appointments, take care of their partner, or manage emotional well-being. Next, compassionate leave. Providing compassionate leave is a key way for employers to show empathy. Many employers offer a set number of days of leave specifically for personal loss or distressing events, including miscarriages. It's essential for employers to clearly define how much leave is offered and under what circumstances. Next, employee assistance programs, sometimes referred to as EAPs. Offering access to counselling and mental health services through an employee assistance program can be extremely beneficial. So employers, take note, because these can help partners cope with their emotions and manage the stress of the situation. Clear communication and sensitivity is another factor. Employers need to create an environment where employees feel safe discussing their situation without fear of judgment. Open and sensitive communication is key to ensuring their partner feels supported and that they are not being made to feel uncomfortable. Next, referral to external support. Employers can provide information about external support services such as charities or organisations that specialise in pregnancy loss, like Tommy's or the Miscarriage Association. These services can provide emotional support, advice and resources for both the affected employee and their partner. Next, training for managers. Ensure managers and HR personnel are trained on how to handle these sorts of situations. It's vital. Next, non-judgmental approach to time off and leave. Employers should be non-judgmental when considering time off for partners. Loss of a pregnancy is often an emotionally difficult and traumatic experience, and partners may need time off to process and support their spouse or partner. Next, protection from discrimination. Employers must ensure that any employee who is experiencing pregnancy loss, including partners, is not discriminated against or treated unfairly due to their situation. This includes ensuring that they are not penalised for taking time off or seeking support. By being empathetic, providing flexibility and offering relevant resources, employers can create a supportive work environment for partners of those who have experienced a pregnancy loss. For more information, please read our article on this topic, which includes a personal account of someone who has experienced pregnancy loss, and it can be found on our website at magaralaw.co.uk and also in the links in the description. To receive legal advice on managing miscarriage in the workplace or get further information about how our employment law and HR retainer for employers, where we provide unlimited advice for a set fee per month, get in touch with us via our website at magaralaw.co.uk or give us a call on 01869 325 883. And for employees, give us a call on the number that I've just provided or get in touch via our website. Thank you for watching, and indeed, don't forget to subscribe. Thank you.